ICUJP has been at it for 22 years since our founding, shortly after 9/11, convened by the Reverend George Regas and a variety of interfaith leaders. We have put on over 1,000 webinars, and we're proud of what we've done under the motto that religious communities must stop blessing war and violence. So we're very proud today to have Marjorie Cohn. So it's a very important day in many respects. Today is actually International Holocaust Remembrance Day, and as well as the issuance of a historic ruling this morning by the International Court of Justice. So there's a lot to talk about. I want to introduce Marjorie Cohn. She is an extraordinary lawyer and professor. Her written biography describes her as a retired criminal defense attorney, professor emerita at Thomas Jefferson School of Law, former president of the National Lawyers Guild, a member of the advisory board of the Assange Defense Committee and the Bureau of the International Association of Democratic Lawyers. She's a legal and political analyst who writes regularly for Truthout. Please go to Truthout. Her articles are cataloged there. She often speaks to the media and has published several books. And she is co-host of the nationally broadcast radio show Law and Disorder, and in her free time is dean of the People's Academy of International Law. This morning, we couldn't ask for a better person to take us through this morning's historic ruling by the ICF. But personally, I want to welcome Marjorie. We have known each other for decades, but we have intensified our friendship and our solidarity in recent years by working for the release of Julian Assange, one of many inhumane persecutions around the world. But I'm going to follow my own adage and allow maximum time for Marjorie, and please make your presentation. And thank you so much on a busy day for being with us.
Well, thank you so much, Steve, for your tireless work and commitment to social justice, and also for inviting me to address you again. As you said, this is a historic day. The International Court of Justice, which is also known as the ICJ or the World Court, has just ordered some provisional measures against Israel in Gaza. But the court stopped short of ordering that Israel suspend its military operations. And I will describe the measures that it did order in a minute. And as you said, Steve, today, a federal court in San Francisco is about to hold a historic hearing in a lawsuit brought by Palestinians against President Joe Biden, Secretary of State Antony Blinken, and Secretary of Defense Lloyd Austin for failure to prevent genocide and complicity in genocide in Gaza. The ICJ convened a hearing, and this was not a hearing on the merits of the petition of South Africa, the application of South Africa to declare that Israel is committing genocide. This hearing was to determine whether or not the court should issue what are called provisional measures. And in order to get provisional measures ordered by the court, South Africa did not need to conclusively prove that Israel is committing genocide. All that is required is a plausible showing that Israel is committing at least some of the charged genocidal acts with genocidal intent. which the ICJ found to be true. The court concluded that the right of the Palestinians to be free from genocidal acts and South Africa's right as a party to the Genocide Convention to ensure Israel's compliance with the convention could be protected by provisional measures. The court found that there is a risk of irreparable prejudice to those rights and an urgency to protect those rights, which are in danger of irreparable injury. The court said it is acutely aware of the extent of the human tragedy that is unfolding in the region and is deeply concerned about the continuing loss of life and human suffering. The court said that it considers that the civilian population in Gaza remains extremely vulnerable. Tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court said that the operation is ongoing and that Prime Minister Benjamin Netanyahu said it will take many more long months. At present, many Palestinians in the Gaza Strip, the court said, have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. So, cutting to the chase, the ICJ ordered the following provisional measures. First, Israel shall take all measures within its power to prevent the commission of all genocidal acts, particularly, first, killing members of the group. Second, causing serious bodily or mental harm to members of the group. Third, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And four, imposing measures intended to prevent births within the group. Second provisional measure that the ICJ ordered was that Israel shall ensure with immediate effect that its military does not commit any of those genocidal acts in point 1 above. Number 3, the court said, Israel shall take all measures within its power to prevent and punish the direct and public incitement to commit genocide. Number 4, Israel shall take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by the Palestinians in Gaza. Number 5, Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence. And 6, Israel shall submit a report to the court on all measures taken to give effect to this order within 1 month of the date of the order. The court also said that all parties to the conflict in the Gaza Strip are bound by international humanitarian law, and stressed that it is gravely concerned about the fate of the hostages abducted during the attack on Israel on October 7th and held since then by Hamas and other armed groups. And the court calls for their immediate and unconditional release. There are 15 judges on the International Criminal Court from all over the world. They added 2 extra judges to make a total of 17 because South Africa and Israel were allowed to appoint 1 ad hoc judge. The votes on these provisional measures were all 15-2, the 2 being the judge from Israel and one of the judge from Uganda. But 2 of the provisional measures were passed with a vote of 16-1. The obligation to prevent and punish genocide, the Israeli judge voted in favor of that, and the obligation to provide humanitarian assistance, again, the Israeli judge voted in favor of that. The Ugandan judge, Sebutinde, voted against all of them, and the Israeli ad hoc judge, Barak, dissented to all but those 2. Now, in anticipation of the decision of the ICJ, Israel declassified more than 30 secret orders of government and military leaders that Israel says rebut South Africa's charge that it is committing genocide in Gaza. Israel claims that the documents actually show that Israel attempted to reduce civilian casualties. The declassified Israeli documents include summaries of cabinet meetings in late October and November, in which Netanyahu ordered supplies of aid, water, and fuel to be delivered to Gaza. In October, he told his cabinet to determine whether external actors could help establish hospitals to treat people in Gaza, and possibly more, a hospital ship off the coast of the occupied territory. Minutes of a November 14th cabinet meeting say that Netanyahu continually stressed the need to significantly increase humanitarian aid to Gaza. Another document said it is recommended to respond favorably to the request of the USA to enable the entry of fuel. Minutes of a November 18th cabinet meeting say that Netanyahu emphasized the absolute necessity of continuing to allow basic humanitarian assistance into Gaza. But the dossier is also highly curated and omits most wartime instructions given by the cabinet and the military, according to the New York Times. The available documents do not include orders from the first 10 days of the war, when Israel blocked aid to Gaza and shut off access to the electricity and water it normally provides to the territory. Now, the court obviously saw these unclassified documents. They mentioned them in the ruling this morning, but they said, yes, we're mindful of that, but it's not sufficient. And so they evaluated those documents against the evidence of what Israel actually did to the Palestinians on the ground. William Shabbos, an international law professor at Middlesex University in London and author of Genocide and International Law, told the Times, when you're trying to prove that you didn't give an order to do something, obviously you're going to show orders that indicate something else. And if there is an order to do something or a plan to do it, you're not going to provide that. On January the 11th, South Africa presented a powerful and compelling case to the ICJ that Israel is committing genocide against the Palestinian people in Gaza. And South Africa asked the court to impose 9 emergency provisional measures to stop the slaughter. And I'll talk about that a little later. South Africa's application, it's like a complaint to the ICJ, places Israel's genocidal acts and omissions in the broader context of Israel's 75-year apartheid policy, 56-year occupation, and 16-year blockade imposed on the Gaza Strip. The siege was described by the director of UNRWA, which is the Refugee Association in Gaza, as a silent killer of people. South Africa told the court that it unequivocally condemned the targeting of civilians by Hamas and other Palestinian armed groups and the taking of hostages on 7 October. But, South Africa said, no armed attack on a state's territory, no matter how serious, even an attack involving atrocity crimes, can provide any justification for or defense to genocide. Israel has crossed the line. Israel responded by placing responsibility on Hamas for the situation in Gaza. It accused South Africa of an attempt to weaponize the term genocide. Israel argued that international humanitarian law is the relevant framework. In other words, that Hamas committed war crimes, and Israel should also be judged by international humanitarian law. In Israel's view, this is not a genocide case. If anyone was the victim of genocide, Israel claims it was on October 7th, when Palestinian resistance forces killed what Israel claims were 1,200 people. However, Hamas is not part of this case because it is not a state party to the Genocide Convention. And the basis for jurisdiction of South Africa is that it is a state party. It has ratified the Convention on Genocide, which includes an obligation to prevent genocide. So, in order to prove genocide, there needs to be two things: an act and an intent. Genocidal act and genocidal intent. And keep in mind that the ICJ did not make a final decision on the merits today that Israel was committing genocide. It found a plausible reason to believe that Israel could have been committing some of the acts, not necessarily all of them, alleged by South Africa. They will decide when they get to the merits stage, which could take several years, whether or not Israel is actually committing genocide. So let's look at South Africa's evidence and Israel's response to the allegation that Israel is involved in genocidal acts. Israel has engaged in a systematic pattern of conduct from which genocide can be inferred, South Africa told the court on the 11th of January. Israel is subjecting Gazans to one of the heaviest conventional bombing campaigns in the history of modern warfare, from air, land, and sea. The level of Israel's killing is so extensive that nowhere is safe in Gaza. Israel has killed an unparalleled and unprecedented number of civilians, with the full knowledge of how many civilian lives each bomb will take. The devastation we submit, South Africa said, is intended to and has laid waste to Gaza beyond any acceptable legal, let alone humane justification. Wherever they go, Palestinians in Gaza are subjected to relentless bombing. They are killed in their homes, in places where they seek shelter, in hospitals, in schools, in mosques, in churches, and as they try to find food and water for their families. They have been killed if they fail to evacuate, in the places to which they have fled, and even while they attempted to flee along Israeli-declared so-called safe zones. Israel has forcibly displaced about 85% of the Palestinians in Gaza. More than 25,000 Palestinians have been killed in the last 3 months, 90% of them civilians. Nearly 60,000 Palestinians have been wounded and maimed, the majority women and children. Hundreds of multi-generational families have been obliterated. The deliberate killing is the destruction of Palestinian life, South Africa argued. No one is spared, not even newborn babies. The scale of Palestinian child killings in Gaza is such that the United Nations has described it as a graveyard for children. Israel deliberately cut off fuel, water, and food to Gaza. South Africa said it was clearly calculated to bring about the destruction of the population. Israel has destroyed or damaged about 355,000 Palestinian homes, and at least 500,000 Palestinians have no home to return to. An unprecedented 93% of the population in Gaza is facing crisis levels of hunger. Of all the people in the world currently suffering catastrophic hunger, more than 80% are in Gaza. Israel's destruction of Gaza's healthcare system renders life unsustainable. In addition, South Africa argued, Israel is imposing measures intended to prevent births among the Palestinians. Israel is blocking the delivery of life-saving aid, including essential medical kits for delivering babies, in circumstances where an estimated 180 women are giving birth in Gaza each day. Now, Israel, for its part, did not contest South Africa's casualty figures. It claimed that while Hamas's strategy is to maximize civilian harm to both Israelis and Palestinians, Israel seeks to minimize civilian harm. Israel asserted that it has the right to defend itself in line with humanitarian law and cited the inherent right of self-defense in the UN Charter and customary international law. Now, military force can be used in self-defense under Article 51 of the Charter if an armed attack occurs against a state, a country, but it must be directed from outside the territory under the control of the defending state. A state cannot claim the right of self-defense to defend against an attack that originates inside a territory it occupies. And since Israel has continued to occupy Gaza, it cannot claim self-defense in response to the attacks by the Palestinian resistance. When Israel presented its case to the ICJ on January 12th, it didn't bother to mention the ICJ's own 2000 advisory opinion on Israel's barrier wall on Palestinian land, in which the court declared the non-applicability of self-defense under Article 51 in the situation between the occupier Israel and the occupied Palestinian territory. So the court itself has rejected Israel's claim that it has a right to defend itself. Now let's turn to genocidal intent, which is the other element required to show genocide. South Africa argued that genocidal intent by Israel is evident from the way in which Israel's military attack is being conducted. It is the systematic mass displacement of the population which is herded into areas where they continue to be killed. It is the deliberate creation of conditions that lead to a slow death. There is a clear pattern of conduct, the targeting of family homes and civilian infrastructure, laying waste to vast areas of Gaza, and the bombing, shelling, and sniping of men, women, and children where they stand, the destruction of the health infrastructure, and lack of access to humanitarian assistance. Moreover, South Africa argued an extraordinary feature of this case is that Israel's political leaders, military commanders, and persons holding official positions have systematically and in explicit terms declared their genocidal intent. Then these statements are repeated by soldiers on the ground as they engage in the destruction of Palestinians and the physical infrastructure of Gaza. Israel's genocidal intent is grounded in the belief that the enemy is not just Hamas, but is embedded in the fabric of Palestinian life in Gaza. Turning Israel's systematic campaign of ethnic cleansing on its head, Israel characterized its evacuation orders and the displacement of 85% of Palestinians in Gaza as humane acts to get them out of bomb's way. They claimed that the Israel Defense Forces dropped millions of leaflets and made more than 70,000 phone calls to warn people to leave their homes to escape the bombing. Israeli lawyer Omri Sender said that Israel is transitioning to fewer ground troops and airstrikes. He said the war shifted a stage to a new and less intense phase of fighting, and Israel will continue reducing the number of troops in Gaza. 5 brigades consisting of thousands of soldiers have already been withdrawn from the territory, he said. Now, although Israel likely announced a change in strategy in anticipation of the hearing before the ICJ, Benjamin Netanyahu made Israel's true intention crystal clear after the hearing, after the January 11th and 12th hearing, saying, quote, "No one will stop us, not The Hague." The Hague refers to the seat of the International Court of Justice in The Hague, Netherlands. So Netanyahu said, "No one will stop us, not The Hague, not the axis of evil," here he's referring to Iran, and not anyone else. In other words, Netanyahu was indicating that Israel did not intend to abide by what the ICJ ruled. Now, South Africa asked the court to order 9 provisional measures to prevent imminent irreparable prejudice to the protected rights of the parties. The first provisional measure that South Africa asked for is that Israel shall immediately suspend its military operations in and against Gaza. This is the most critical provisional measure that South Africa asked for, and it is the one that that the ICJ refused to order. So although the ICJ did order a number of provisional measures, they did not say that Israel has to stop bombing Gaza, which is very worrisome. And South Africa also asked that that not only that Israel ensure that any military units and irregular armed units, organizations, or persons which may be directed, supported, or controlled by or influenced by Israel, such as armed settlers, which have been operating in the occupied West Bank with the support from the military, that they take no steps to further military operations. And the provisional measures that the ICJ ordered didn't say anything about these irregular individuals or groups. The third provisional measure that South Africa asked for is that both South Africa and Israel take all reasonable measures within their power to prevent genocide. Fourth, they said that Israel should be ordered to desist from committing genocidal acts. And they include killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births within the group. And as I said, the ICJ did order that. Also, South Africa asked the ICJ to order that Israel desist from and take all measures within its power, including the rescinding of relevant orders, restrictions, and prohibitions, such as orders for them to evacuate and move, which has been identified as a genocidal act. And part of that provisional measure that South Africa was asking for was rescinding of orders to prevent the expulsion and forced displacement of Palestinians from their home, the deprivation of access to adequate food, water, humanitarian assistance, fuel, shelter, clothes, sanitation, hygiene, and medical supplies and assistance, and also any restrictions or orders regarding the destruction of Palestinian life should also be rescinded. They did not order that one, the court. And then it says that Israel shall ensure that its military and these irregular armed forces and individuals don't commit any acts punished by the genocide, and if they do, they should be punished. Again, the ICJ didn't take the provisional measures that South Africa was asking for word for word. They basically imposed their own, but with some of the substance. So they did order that Israel not commit any acts punishable by genocide. And then another provisional order that South Africa asked for is that Israel shall take effective measures to prevent the destruction of evidence of alleged genocidal acts. And the ICJ did order that, but also the South Africa was asking for a provisional measure that said that Israel shall not deny or restrict access by fact-finding missions, international mandates, and other bodies to Gaza to help ensure the preservation and retention of evidence, and the ICJ didn't go that far. Then South Africa asked the ICJ to order that Israel submit a report to the court on all measures taken to comply with the order within a week. The court actually ordered that Israel report on its progress on these provisional measures within a month. And then South Africa asked that the ICJ order that Israel refrain from any action and ensure that no action is taken that might aggravate or extend the dispute before the court and make it more difficult to resolve when it gets to the merit stage. The ICJ did not order that one as well. Now, if these measures are binding, that means that they have the force of law, the provisional measures that the ICJ ordered. But the court does not itself have enforcement power. They will then go to the UN Security Council for enforcement. Now, we all know that the United States as one of the permanent members, the 5 permanent members of the Security Council, has a veto. And in fact, the US has used its veto several times to prevent the Security Council from ordering that Israel stop its genocide, and so basically providing diplomatic cover to Israel, which is a function that the US government has played for many years under all administrations. What could the council do if it were so inclined to enforce these provisional measures? The council could order economic or trade sanctions against Israel, arms embargoes, travel bans, and even military force. Highly, highly unlikely. Now, if the US vetoes enforcement measures in the Security Council, the fact that the ICJ found a plausible case to be made that some genocidal acts were being committed by Israel could prompt other countries to impose sanctions on Israel. Also, the UN General Assembly could convene under Uniting for Peace. It's a procedure to circumvent a deadlock in the Security Council. The General Assembly could recommend a trade embargo and deployment of a UN military force or suspension of Israel from the General Assembly. Now, the ICJ's finding that South Africa established a plausible case of genocide by Israel may embolden individual countries to prosecute Israeli leaders and officials for genocide under the well-established doctrine of universal jurisdiction. Genocide is so heinous, it's considered to be a crime against all nations, so any country can punish it. And in fact, Israel used universal jurisdiction to try, convict, and execute Adolf Eichmann, the so-called architect of the Holocaust, for crimes that were not directly related to Israel under this doctrine of universal jurisdiction. In addition, when the ICJ, if and when I should say, the ICJ does make a finding of genocide at the merits stage, that would bind the International Criminal Court, the ICC, which would then only need to decide which individuals to prosecute. After a 5-year preliminary examination, former ICC Chief Prosecutor Fatou Bensouda found a reasonable basis to believe that Israeli leaders committed war crimes and crimes against humanity in Palestine, including willful killing, willfully causing serious injury, disproportionate use of force, and transfer of Israelis into Palestinian territory. Bensouda also found a reasonable basis to investigate possible war crimes by Palestinian leadership, including intentional attacks against civilians, using civilians as human shields, and torture and willful killing. The ICC opened a formal investigation of what they call the situation in Palestine more than 3 years ago. But no arrest warrants have issued, and there's been no visible progress toward accountability for Israeli leaders. The current ICC prosecutor, Karim Khan, is very pro-US and has succumbed to pressure by the US government not to bring Israeli leaders to justice. But if the ICJ were to conclude that Israel has been committing genocide, that would give the ICC prosecutor political cover to bring charges against Israeli officials for genocide. So stay tuned. The Biden administration has refused to say whether it would abide by the decision of the ICJ. On November 16th of last year, the Center for Constitutional Rights, or CCR, on behalf of 2 Palestinian human rights organizations, 3 Palestinians, and 5 Palestinian Americans, brought an emergency motion in the U.S. District Court of Northern California to immediately force Joe Biden, Antony Blinken, and Lloyd Austin to stop providing additional weapons, money, and diplomatic support to Israel, which is committing genocide in Gaza. The emergency motion came days after the same group of Palestinian plaintiffs sued Biden, Blinken, and Austin in U.S. District Court for the failure to prevent genocide and complicity in genocide. The complaint, which had been filed on November 13th after more than 5 weeks of Israel's unrelenting slaughter in Gaza, alleges violations of the Genocide Convention, the Genocide Convention Implementation Act, which is the U.S. statute, and customary international law, which forbids genocide. The plaintiffs include Defense for Children International Palestine, Al-Haq, 3 Palestinian individuals who reside in Gaza, and 5 Palestinian Americans who have families in Gaza. Article 1 of the Genocide Convention imposes a duty on all states parties, which include Israel and the United States, who have ratified the treaty, to prevent genocide. The ICJ said in the case of Bosnia and Herzegovina versus Serbia and Montenegro that a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of or should normally have learned of the existence of a serious risk that genocide will be committed. Now, CCR's motion for a preliminary injunction charges that defendants, this is Biden, Blinken, and Austin, have been on notice of the risk of genocide since at least October 9th, if not already on October 7th, through the public and widely circulated statements and actions by Israeli officials with whom they were in close, regular contact and consultation, as well as by warnings of indicators of genocide from United Nations officials and other sources that have only increased since then. Reports and images of Israel's assault on the Palestinians in Gaza, accompanied by words and actions of Israeli leaders revealing the intention to ethnically cleanse Gaza of Palestinians, have been ubiquitous. Yet instead of fulfilling their legal duty to prevent the unfolding genocide, Biden, Blinken, and Austin poured gasoline on the fire by sending Israel vast amounts of weaponry, money, and advisory support. On October 18th, for example, the U.S. vetoed a UN Security Council resolution that would have called for a ceasefire and urged Israel to rescind its order to 1.1 million Palestinians in northern Gaza to leave their homes and move to southern Gaza. Now, complicity to commit genocide can only occur if there is a punishable act of genocide by another state or persons. The accomplice enables or facilitates the crime, but doesn't have to share the specific intent to commit genocide. A defendant may be liable for genocide if he knowingly provides assistance, encouragement, or moral support for the crime. Furnishing arms and ammunition and operational support and advice that armed forces use to commit atrocities can constitute aiding and abetting if the defendant knew his actions would assist the international law violation. So the Palestinians' lawsuit brought by CCR charges that defendants Biden, Blinken, and Austin transferred a significant amount of weapons and military equipment to Israel. And they asked Israel to appropriate, the Biden, Blinken, and Austin asked Congress to appropriate $14.1 billion in additional military assistance to Israel. Now, keep in mind that the U.S. supplies Israel with $3.8 billion a year in military assistance. That was a number that was arrived at during the Obama administration, a 10-year commitment to $3.8 billion a year. So Blinken authorized a this is another allegation by CCR. Blinken authorized a $320 million transfer of military equipment to an Israeli manufacturer of kits for precision bombs. U.S. leaders, CCR alleges, are intimately involved in day-to-day assistance to Israel as it bombards Gaza. On October 30th, Defense Deputy Press Secretary Sabrina Singh stated that Defense Department and all other officials, all the way up to the president, have certainly informed and at least guided some of what the Israelis are doing on the ground in their ground operation. U.S. officials refused to place any limitations on Israel's use of U.S.-furnished weaponry to carry out its genocidal assault on the Palestinians in Gaza. And of course, this violates the Leahy Law, which says that the U.S. cannot supply military assistance to countries that commit gross violations of human rights. On November 7th, Singh admitted that we don't put conditions on weapons that we're sending or that Israel is using. No conditions. Finally, according to the CCR complaint, Biden continues to refuse to call for a ceasefire. And in fact, he continues to refuse to call for a ceasefire. On November 9th, when asked at a press briefing about the chances of a ceasefire, Biden replied, none, no possibility. The CCR complaint states, as Israel's closest ally and strongest supporter, being its biggest provider of military assistance by a large margin, and with Israel being the largest cumulative recipient of U.S. foreign assistance since World War II, the United States has the means available to have a deterrent effect on Israeli officials now pursuing genocidal acts against the Palestinian people in Gaza. And you will note, if you remember, that when I mentioned what provisional measures, well, not the provisional measures, but the unclassified documents that Israel provided to the ICJ in advance of today's hearing, it talked about providing humanitarian assistance as requested by the U.S. So that corroborates the CCR's allegation that the U.S. does have some measure of influence over what Israel does with its weapons and in this campaign. In their lawsuit, these Palestinian plaintiffs are asking the federal court in San Francisco to declare that defendants Biden, Blinken, and Austin violated their duty under customary international law as part of federal common law, first, to take all measures within their power to prevent Israel from committing genocide against the Palestinian people in Gaza, and number two, that prohibits their complicity in genocide by knowingly continuing to provide assistance that enables and facilitates Israel's commission of genocidal acts against the Palestinian people in Gaza. The plaintiffs in the CCR lawsuit are also seeking an injunction ordering the defendants to take all measures within their power to prevent Israel's commission of genocidal acts against the Palestinians in Gaza, including but not limited to ordering defendants to exert influence over Israel to end its bombing of the Palestinian people of Gaza, resulting in mass killing and serious injury, lift the siege on Gaza, and allow all electricity, food, fuel, water, and humanitarian aid into Gaza, and prevent the evacuation or forcible transfer and expulsion of Palestinians from Gaza and ensure their freedom of movement. Finally, the plaintiffs are asking the federal court to issue an injunction to prevent Biden, Blinken, and Austin from providing, facilitating, or coordinating military assistance and financing to Israel, including sales, transfer, or delivery of weapons and arms to Israel, and providing military equipment and personnel, advancing Israel's commission of genocidal acts, and obstructing attempts by the international community, including the UN, to implement a ceasefire and lift the siege on Gaza. Now, at 9 o'clock this morning, there is going to be, as I said, a historic hearing in federal court on the CCR's request for an emergency injunction. It will last for several hours. The witnesses who will testify at today's hearing include some of the Palestinian plaintiffs and a genocide expert. The broadcast of a federal hearing is not a common occurrence. It attests to the public importance of charging the president and two high cabinet members with complicity in genocide and failure to prevent genocide in Gaza. It's also significant that a few days ago, the Washington Post published an article on the BDS movement, boycott, divestment, and sanctions. BDS movement was launched in 2005 when 170 Palestinian civil society organizations called for the boycott, divestment, and sanctions, nonviolent punitive measures to last until Israel fully complies with international law. And to do that, Israel must first end its occupation and colonization of all Arab territory and dismantle the barrier wall. 2, recognize the fundamental rights of Israel's Arab Palestinian citizens to full equality. And 3, respect, protect, and promote the rights of Palestinian refugees to return to their land as mandated by UN General Assembly Resolution 194. Boycott is the withdrawal of support for Israel, as well as Israeli and international companies, including cultural and academic institutions that violate the Palestinians' human rights. Divestment means that churches, banks, universities, pension funds, and local councils withdraw their investments from Israeli and international companies that are complicit in violating Palestinian human rights. And sanctions involve governments ending military trade and free trade agreements and the expulsion of Israel from international fora. The successes of the BDS movement have prompted Israel lobby organizations, including the right-wing Christian Zionist groups, to introduce anti-boycott legislation at the local, federal, and state levels, and they violate the First Amendment. We have a very proud history of boycotts in this country, including during the civil rights movement, anti-apartheid movement, etc. And the interest in BDS has grown exponentially, especially on social media, since October 7th. So I want to stop there because I know I've been going on and I think people are probably zoning out. I think we're going to move to a Q&A session, and thank you for listening, and I'm sorry that I have to leave early. Thanks.
Thank you, Marjorie. I am so glad this has been recorded. Just an extraordinary amount of clarity that you bring to every one of these issues. I'm going to ask a quick series of questions, and then folks should raise their hands as needed. We have until 8:45. Marjorie needs to leave to listen to that court hearing in the CCR case. I've been frantically reading the ruling of the court. It does order that Israel cease the killing of members of the group. The group is recognized as the Palestinians. Why isn't that, except for name only, a call for a ceasefire?
Yes, I see what you're saying, but they are not specifically ordering that military action stop. And Israel has been arguing, we're not really intentionally killing civilians. We're targeting Hamas, and we're sorry if civilians have been killed, but we are trying to protect civilians. So it gives Israel wiggle room, which a provisional measure as requested by South Africa ordering Israel to cease military operations against the Palestinians in Gaza would have done.
Secondly, the group is defined as Palestinians. Members of Hamas are Palestinians, by and large. Isn't that an order to stop killing members of Hamas?
In effect, it is. In effect, it is, but they're not spelling it out. And Hamas certainly, they certainly are members of the group. As I said, under the ICJ's case law itself, Israel does not have a right to self-defense against people in territories it occupies. Of course, it's just accepted. It's in the corporate media. It's kind of a mantra that people, of course, Israel has a right to protect itself, to self-defense. I submit that if Israel really was concerned about its own security, it would end the illegal occupation, provide equal rights for Palestinians, and stop arresting thousands of Palestinians with no charges, no due process, and all of the other things that have been documented. That's the way to keep Israel safe, not by committing.
Right. On the question of self-defense, Israel argues that since 2006, it is no longer an occupying power in Gaza. Therefore, it has a right of self-defense. Did the court address that? Did South Africa address that? And would you address that?
No, yes, and yes. The court did not address it. South Africa alluded to it. I will address it. And that is that Israel likes to say that it ended its occupation of Gaza in 2006 because it pulled its troops out of Gaza and the settlements, the Israeli settlers were pulled out. However, Israel maintained a very, very tight blockade on Gaza, controlling everyone and everything that came into and out of Gaza, all ingress and egress into Gaza. They control the airspace of Gaza. They control the waters around Gaza. They control the infrastructure of Gaza. They control the electricity, the food, the water, everything that enters into Gaza. And therefore, under the legal test of effective control for definition of what is occupied territory, Israel is still occupying Gaza and has been continually.
In releasing the 30 or so declassified documents, Israel argued, how can we have a genocidal intent if we are taking all steps or multiple steps to provide humanitarian relief? Who tries to commit genocide and simultaneously provide humanitarian relief? What are your thoughts on that argument?
Well, if you buy that, I've got a really good deal on a bridge to sell you, Steve. The reality of what we are witnessing with our own eyes on a daily basis, which has penetrated even the corporate media, it's all over social media, it's all over the alternative media. What Israel is actually doing puts the lie to its few statements that it supposedly declassified about how it's providing humanitarian aid. The reality of all of the overwhelming evidence that was presented by South Africa and that we've been witnessing ourselves shows a very, very different picture. And in fact, as I mentioned, the ICJ did mention that Israel has claimed that it is providing humanitarian aid, but they said it is not enough. So the court did acknowledge those declassified documents at the 11th hour on the brink of the hearing today, or right before the hearing today, but it dismissed them as not being sufficient to undercut South Africa's plausible case that Israel has engaged in at least some of the genocidal acts that South Africa is alleging.
Thank you. If time permits, I'll circle back to myself, but we have three questioners so far, Carol Francis, Dave Clennon, and Michael Jacobson. Go right ahead.
Okay. I'm really concerned about how much genocide can happen in the next month before the court rules on whether Israel is abiding by it or not. Is there any means of, or any possibility of, if it becomes clear that Israel's going to ignore this whole thing, and it states that, like you said, it quoted Netanyahu saying, "No one can stop us." Is there any provision for the court to reconvene and say, look, we're not going to give them another month because they're obviously not taking this seriously?
It's not going to happen, Carol Francis. The court has ordered Israel not to commit genocidal acts and to do other things. They will either comply or not. And it is up to the Security Council to enforce those provisional measures that the ICJ ordered. We'll see what the Security Council does. And the 1 month is just an amount of time for Israel to provide a report to the ICJ about its progress in complying with those provisional measures. But, you know, there's another thing that is going on here, even though the ICJ did not specifically order Israel to cease its military action. And that is what we call in international law the mobilization of shame. This is a real thing. The mobilization of shame. Israel, in coming before the World Court, in trying to defend what it is doing, the World Court finding a plausible case of genocide, shames Israel in the eyes of the international community. And hopefully that will spur the General Assembly to convene under Uniting for Peace, as I said, and individual countries to bring Israeli leaders to justice under universal jurisdiction.
With 10 minutes left, we'll take quick questions and quick answers from Dave and then Michael.
Hello, Marjorie. Thank you for that presentation. My question is this: at some point, the Israeli military might decide that they have obliterated enough of the Palestinian infrastructure, if not all of Palestinian infrastructure, which makes life possible. And it's at that point they might cease the bombing campaign and claim that and then the ICJ ruling could be supposed to be irrelevant at the point when Israel ceases to bomb and shell and rocket the Gaza territory. So I guess what I'm asking is, as time passes and more destruction is levied against Gaza, does the ICJ ruling become less relevant, or could Israel claim that it's less relevant to an extent that our mainstream media might say, yeah, we agree with them? Thank you.
Yes, Israel's certainly going to claim that, but I don't think it's just a question of the military thinking it's destroyed enough of the infrastructure. The statements made by Israeli high officials have made it clear that Israel's intention is to move all the Gazans out of Gaza, hopefully force them into the Sinai, into Egypt, into other Arab countries. And the countries are not cooperating at this point, but they want to completely ethnically cleanse Gaza of Gazans. And they're going to take as long as they feel like taking. They could take years. And it's only if the international community stands up and says no, the Security Council, the General Assembly, and countries around the world, that Israel will stop. Now, this, although the ICJ did not actually order Israel to stop bombing, this is still a very, very significant ruling. And Israel, is probably relieved that they didn't order them to stop bombing, but is not happy about the rest of the measures that were ordered. And it's going to take a few years to actually have a ruling on the merits, but Israel will go down in history, assuming that the ICJ finds at the merit stage that Israel is committing genocide, as a committer of genocide. Israel just in their defense at the ICJ, they were just stupefied that Israel, of all countries for whom the Genocide Convention was actually enacted, could be possibly accused of genocide. They just can't even imagine it. They said if anybody's should be accused of genocide, it's Hamas for killing what Israel said are 1,200 people. So I do think it's significant. I see what you're saying. You're saying it will be moot if Israel does enough destruction that it wants to stop. I don't think it will be moot.
Okay, Marjorie, this is a question that's probably outside of this issue of the South Africa case, but why is it and how can it ever be changed, this power of the US and the other 4 nations with the veto power, that when the General Assembly comes across with some limitations on actions of Israel, it's just vetoed with a raise of a hand? Could you just briefly speak to, is there any possible way of eliminating that, the strength of that veto power?
It's a really good question. The U.S. vetoes Security Council resolutions, not General Assembly resolutions. The U.S. is one of 194 countries in the democratic body, the General Assembly. U.S. votes against any criticism of Israel, but can't veto. After World War II, it was the victorious powers that made themselves the permanent members, and if that with a veto, and if that had not happened, then they would not have agreed to establish the UN system, and that's the reason that we have that. It's not going to change anytime in the near future, unfortunately. There's no way. So the Uniting for Peace procedure in the General Assembly is an alternative when the Security Council is deadlocked because of a veto. It actually was an initiative by the United States in 1950 when the U.S. wanted to invade North Korea, and the Soviet Union was boycotting the Security Council on this issue. So the Uniting for Peace, they say the General Assembly resolutions don't have binding force, but when they meet under Uniting for Peace, it is a very, very strong recommendation, and it can urge individual countries to impose sanctions on Israel, arms embargoes, boycotts, etc.
We're going to take the final 2 questions. We have almost 5 minutes. So 2 questions we'll take together. Marjorie, if you want to make notes, and then you can combine your answers. We'll go to Rebecca and then Vinny.
I wanted to ask, there was Congress sent a letter to Anthony Blinken a couple of days ago, and it was very strong and very broad in claiming that South Africa has filed a grossly unfounded case against Israel at the International Court of Justice. And we write to express our disgust at this filing. And it goes on to say that the case was defamatory of Israel and delegitimizes them. So it wasn't really so much focused on the genocide claim, but the case on the whole. And as we've seen, the court didn't just throw the case out. Could this be evidence of the U.S.'s complicity at some point? Would something like this be considered our intent to be complicit in this genocide? And the second part of that is, my congressperson signed on to this too. Could we have a basis to ask our state attorney generals for investigations of some kind into how they are spreading this false propaganda with no merit? There's no mention of this, of even Israel's occupation, of course.
Okay.
So that's it.
So there's the letter from Congress, and you'll comment on that. Vinny, a short question.
Very short question. John Mearsheimer has said that irrespective of what happens with the ICJ's ruling, that this will have lasting damage for the state of Israel, and of course the United States as well. And it appears that the ICJ ruling is, for all intents and purposes, toothless without a ceasefire. Marjorie, what do you believe the long-term implications for the state of Israel be now that it appears to be a pariah state in the world, but acts with impunity?
Okay, both very good questions. Yes, the most powerful lobbying group in this country is AIPAC on behalf of Israel, and the AIPAC has many Congress members of both parties in its hip pocket, which is one of the reasons why every time there's any criticism of the Israeli regime, it is dismissed with the excuse that it's anti-Semitism. So yes, this is Congress members writing a letter. It is not a formal vote of Congress. I don't know that it could actually be evidence of a complicity in the courts, complicity to commit genocide, which is what's one of the charges pending now against Biden, Blinken, and Austin in the federal court. They don't need an intent to commit complicity. That's an intent to commit genocide, but certainly that could be brought in as evidence of what some Congress members are thinking, but I don't know that they actually could be brought up on charges of complicity to commit genocide.
1 minute warning.
Pardon me?
1 minute.
Yes, and Vinny, lasting damage to Israel, even though it has enjoyed impunity. The mobilization of shame on steroids, and B, maybe not impunity, because look what CCR is doing in federal court and what we can expect other countries to do, hopefully under universal jurisdiction. People have known what Israel's been doing all these 75 years. Israel has taken it to a new and totally unacceptable level.
Marjorie, we are immensely grateful. You are already a card-carrying member of ICUJP. Thank you. Go watch the court hearing, and we look forward to your reporting back on that.
Thank you.
Thank you, Marjorie.
Thank you for inviting me, for listening, and for all your great questions. I appreciate it.
All right. I'm going to reflect this morning on the question of condemning Hamas. First, some data. Israel's Operation Cast Lead killed 1,397 Palestinians. Its Operation Protective Edge killed over 2,142 Palestinians. And during the Palestinian peaceful protests, the Great March of Return, Israel killed 266 Palestinians. That's a total of 3,795 Palestinians killed in Gaza by Israel, paid for by our tax money before October 7th. Then there are the traumatized, the hungry, and the 20,000 injured during the Great March of Return, where soldiers were aiming for knees so that that child, woman, or man would never again be able to walk in a normal way. That's in Gaza alone, separate from the Palestinians imprisoned, injured, or killed in the West Bank. This reality, on top of the horrendous day-to-day existence in that concentration camp called Gaza, led to October 7th, in which 1,200 Israelis, according to Israel, were killed. And that led to over 25,000 Palestinians being killed, which is ongoing. Gabor Mate, the Hungarian Jewish Holocaust survivor, ex-Zionist, and expert in recognizing and treating trauma, said, "You think the worst thing you can say about Hamas, multiply it by 1,000 times, and it still will not meet the Israeli repression and killing and dispossession of Palestinians." Yet, We are commanded by Zionists, upheld by the capitalist press, to condemn Hamas for killing Israelis on October 7th before we're allowed to condemn the actions of Israel since then. They demand that before we speak of Israel committing genocide, we must first describe Hamas as cruel, evil, a terrorist organization or such. Yet they're not required to denounce Israel or the United States for the killing of more than 3 times as many Palestinians in Gaza leading up to October 7th. They're not compelled to call these two governments terrorist states before expressing their anguish over the loss of Israeli life. This means they're demanding that we hold colonized people to a higher standard than we hold their colonizers, that we consider Israeli lives more sacred than those of 3 times the number of Arabs. Though I mourn the loss of all life, I refuse to accept this. This reminds me of Dr. Martin Luther King in his Beyond Vietnam speech, saying that he could never again raise my voice against the violence of the oppressed in the ghettos without having spoken first clearly to the greatest purveyor of violence in the world today, my own government. What options do Palestinians have? I know of only 4 responses to oppression. 1, accept it and do nothing. 2, flee the scene. 3, engage in nonviolent action. Or 4, commit violence. Am I missing anything here? Or are there other possibilities? For Palestinians, this means 1, accepting never-ending, traumatizing brutality to their families. 2, becoming refugees and thereby reward their oppressors with their land. 3, engaging in nonviolence constantly for years and getting imprisoned, injured, or killed for it while the world ignores you. Or what? 4, what? Does that mean I condone Hamas's killing of innocent people? No. But recall Dr. King speaking of Vietnam's National Liberation Front, the so-called Viet Cong. In that same talk, he said, surely we must understand their feelings, even if we do not condone their actions. Surely we must see that the men we supported pressed them to their violence. And so, as we grieve for innocent lives taken on October 7th, let us condemn the 2 terrorist states that pressed Hamas to their violence. And in that same speech, Dr. King quoted President Kennedy in saying, those who make nonviolent revolution impossible will make violent revolution inevitable. And it would be arrogant of us, the world's comfortable few, to sit well-fed in our comfortable homes and condemn the oppressed, having no idea what we would do in their situation. What we must do instead to end terrorism starts, but does not end with this. Ceasefire now.
Thank you, everyone. Be safe. There's a flare-up of COVID. I'm hearing about it in many places, so be extra safe. And please join us next week as Rick outlined the program.
Really important.
Be kind to each other and be well. Thank you.
Yeah.
Bye-bye.